Listen on TuneIn and Odyssey.
The United Church of Canada embraces doctor-assisted suicide.
The controversial practice is becoming increasingly common in the country, and now the UCC has approved so-called euthanasia prayers. They are denominationally approved prayers for individuals who have decided to take their own life. Alex Schadenberg of the Euthanasia Prevention Coalition says, quote, people should always have compassion for those living with physical or mental illness, but the United Church is praying for and approving the act of killing. Michael Harrington, SRN News.
Clergymen say Damar Hamlin's brush with death during an NFL game last month has reintroduced the league and the nation to prayer. Eagles chaplain Ted Winsley says the prayers were impacted because they were seeing themselves, and that it also causes you to come to grips with the fact that there's someone greater than you and that you have to trust in. And another player says it was very comforting to see a huge outpouring of support through prayer. This is SRN News. China's TikTok is expanding.
TikTok is planning 2 more European data centers as the popular Chinese-owned video sharing app seeks to allay growing concerns about data privacy for its users in the West. The company says it's finalizing a plan for a second data center in Ireland following its first announced there last year.
That is correspondent Keith Peters. A governing body of Formula One clarifies its ban on driver comments.
Recently issued guidance barred drivers from making political, religious, and personal statements without prior consent and expressed no limitations on where that restriction applied. Drivers were nearly unanimous in their criticism of the ruling. Friday's clarification puts limits on when the FIA can apply the rules. The restrictions will be upheld during pre- and post-race events and on the track. Rhonda Rockster reporting.
More of these stories at srnnews.com. From Washington, I'm Bob Agnew.
The following program is sponsored by the law offices of Patrick L. Smith. This is the Attorney Patrick Smith Show. Get ready with your legal questions and call Patrick now. 877-943-9673. Again, that's 877-943-9673. The law office is open. And now your host, Patrick Smith.
Oh, hi there, and welcome to another edition of the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. Today is Saturday, February 18th, and we will be with you for the next hour to answer all of your legal questions. Again, that open studio line, 877-943-9673, 877-943-9673. You know, I had just finished prepping my monologue for this morning's intro, but in real time, I heard something in the news there at the top of the hour discussing the right to die legislation. And I realized we haven't discussed that yet on the show. So several states, including California, Colorado, District of Columbia, Hawaii, Montana, Maine, New Jersey, New Mexico, Oregon, Vermont, and Washington currently allow euthanasia or physicians-assisted suicide. Notice that Florida is not one of those states on the list. And we have not yet taken the temperature of you, the Attorney Patrick Smith Show Nation. What do you guys think about that? Are you for physician-assisted suicide in the state of Florida? Are you against it? Do you have an opinion on it, a rationale behind it? So just quickly off the top of the show, if you have an opinion on that, 877-943-9673, 877-943-9673. I work a lot with the elderly daily. So I see a lot of people enter those end-of-life days and the struggles that come along with that, and often find myself wondering, what that must be like to go through those final days. So maybe you have an opinion. 877-943-9673. I'm not aware of any current legislation regarding euthanasia or physicians-assisted suicide making its way through the Florida legislature, although I do, for today's show, have some new legislation that is making its way through committee. But if you have an opinion on that, 877-943-9673. Give us a call now. You can also email in your thoughts or legal question, patrick@attorneypatricksmith.com, patrick@attorneypatricksmith.com. And I'm local Central Florida Attorney Patrick Smith, born and raised here in the Sunshine State. Now, Own my own practice with offices throughout the Central Florida area, including Clearwater, Sun City Center, Sarasota. And you can call our office line if you would ever like to schedule a complimentary consultation. The office line, 877-754-6764. I'll give out that number for the early crowd, 877-754-6764 for everyone who would like to schedule their complimentary consultation. But to talk to us today, 877-943-9673, 877-943-9673. Brian, the call screener, standing by, ready to screen your calls and get you and your legal questions on the air. All right, now back to my regularly scheduled monologue for today's program, Florida homestead law. So as I was leaving the studio a couple of weeks ago, and we kind of touched on homestead as it related to another topic, and a caller, Brian, the call screener, said, hey, phones really blew up when we discussed homestead. You may want to revisit that topic. So in our diligent effort to give you what you want here at the Attorney Patrick Smith Show, here we go with Florida homestead law. First of all, I think the key thing to understand with regard to homestead is the fact that it is not just one thing. I think you have to understand that Florida homestead law is actually codified and memorialized in two separate places. First of all, there's Florida Statute 196. This is the provision regarding your property taxes. Now, for a lot of people, that starts and stops their homestead analysis. They know about filing their homestead exemption, and that deadline is coming up. This is part of the reason why we're doing the show. So the deadline is March 1st, so long as you owned the property prior to January 1st of this year. So that would be your time to apply for the homestead exemption. And this is where you get the break on the first $25,000 and the additional $25,000. So a total of $50,000 tax-free under the homestead exemption. The additional $25,000 that pushes it to $50,000. By the way, the property has to be over a certain threshold in value to meet that requirement. But if you get this and you qualify, what do you need to qualify? Well, when you show up to the property appraiser's office, I always recommend calling ahead of time and just double checking with them that you have everything that they will need. It's often just easier to make a phone call than show up and realize you're missing a document and having to make a couple of trips. But the things you should plan on taking: your Florida driver's license, all right, your Florida car registration, and your Florida voter ID. And all these things ought to bear your homestead property address. And you want to do this before March 1st of this year if you're trying to qualify for your Florida homestead exemption. Now, this will also opt you into the Save Our Homes provision regarding the 3% increase in the property tax value. So if you make this election, then every year you'll get the notice from your property appraiser that you have homestead on this property, and they'll let you know you have the opportunity to cancel it if you've sold that property, bought another property that you want to homestead, so they will give you a notice. But basically, the homestead will continue in most counties unless and until you cancel it. So if you have a question on homestead, 877-943-9673, 877-943-9673. Open studio lines will get you and your call right on the air. Give us a call now or email me, patrick@attorneypatricksmith.com. Again, that email address, patrick@attorneypatricksmith.com. So give us a call now, 877-943-9673. So the question then becomes, can you file late? You can. It's not necessarily a guarantee, but technically under the rules, you have until 25 days after the trim notice goes out, which is usually that deadline would then pass sometime in early September. And then the question also comes up, well, can I file online? Check with your county. And many counties now do allow you to file online for your homestead exemption, but you want to check with your county to make sure that everything's done properly and appropriately, and you don't miss that deadline and wind up doing a late filing. 877-943-9673. That's your live and local number to be part of today's show. 877-943-9673. Give us a call now. And then the question always comes up in the office, what about multiple homestead exemptions? If we're a married couple, can we have exemptions on more than one property? And this is a very narrow option. You can actually, as it turns out, have multiple homesteads if you're a married couple sort of living independently, but it's a pretty strict test, pretty lofty standard. It's not easy to qualify for, and it's definitely not the loophole that a lot of people are looking for when they say, hey, I'm going to have a property up north, I'm going to have one here in Florida, and I'm going to attempt to get homestead in both states, but we really just live in one state. The other one's a vacation property. That'll get sniffed out eventually. And I think that it's really designed for, a couple that happens to just live separately because of something in their living relationship or their marriage. And that might be successful in getting multiple homesteads, but otherwise going to be pretty difficult to meet that standard. So 877-943-9673. That's your live and local open studio line. Give us a call now or email your question, Patrick at attorneypatricksmith.com. Patrick at attorneypatricksmith.com. Give us a call now. First email question of the day. Can I put my homestead property into my revocable living trust? Yes, you can. So this question we quite commonly get is, can I or should I put my homestead property? And you hear people all the time who say things like, well, I was told I shouldn't put my homestead property in the trust. And I think that it's important that when you move your homestead property to your trust, you do so with recognition to the fact that it's your homestead. And I think you do that on the transferring deed. And more importantly, in the trust itself. I think in the trust, you have to show acknowledging that the trust is designed to hold Florida homestead property. So there should be a clear call out, in my opinion, for Florida Statute 196 saying that, the grantors here intend to maintain the present possessory interest under Florida Statute 196 to maintain their property tax homestead exemption. So now all of that, everything we just covered, for most people is the entire knowledge they have with regard to Florida homestead law. For many of you, you're thinking, yeah, that's all I know about homestead law. Okay, then part 2 of this monologue is going to be a breath of fresh air and a wealth of new knowledge for you. So part 2 of this is the constitutional provision of Florida homestead. And this lives in Article 10, Section 4 of the state constitution. That's why if you scour Florida statutes, you won't find this because it lives in the highest body of law in the state of Florida, the state constitution. And the state constitution lays out a couple of key points regarding constitutional homestead analysis. First of all, the constitutional homestead protection. So the state constitution protects the home from creditors so long as it meets 2 geographic limitations: half acre within the city limits, 160 acres outside of the city limits. And that is designed to protect your home, to make sure you have a place to live. Now, there's a couple of exceptions. Mechanics liens are an exception. Good example of that is you pay, or you have someone come on the property to do work for you and you don't pay them. They can lien the property. The other one, obviously, your property tax lien. If you don't pay your property taxes, they can obviously file a tax lien against you. But other than those exceptions, you'll notice that you are creditor free with regard to your homestead property. The other thing that notice what's missing from this analysis, there's nothing about an economic cap. It's all geographic. So the property's value is irrelevant to this analysis as far as being creditor protected. So the other side of this coin. So we're going to give you creditor protection under the state constitution, but we are going to require that you protect that property for certain people who should be important to you. All right, before we get into that, let me give you out the phone line one more time, 877-943-9673. So right now we're discussing Florida homestead law. You're welcome to call in with your thoughts, questions on Florida homestead, 877-943-9673, or email your question, Patrick at attorneypatricksmith.com. So give us a call now, 877-943-9673. All right, the part 2 of the constitutional side of Florida homestead law has to do with restrictions on devise, meaning how you can pass along this property. Number 1, we'll talk about the restrictions for minors. So if you're out there, and as I announced last week, that we will be doing the solo parent conference at Indian Rocks Baptist Church coming up here in March. But actually, that just reminds me, we will actually be speaking at Indian Rocks Baptist Church this Wednesday. So this Wednesday, the 22nd, we will be there at 6:30. So if you want to reach out to Indian Rocks Baptist, you can RSVP to attend that event. And then stay tuned for our solo parent conference we're doing in March. The church has all the information there as well, can get you signed up for that. The reason why I bring up the solo parent conference, this commonly is an issue that single parents face because they own property and they have a minor child. The state can restrict the devise of that property if it's your homestead to protect it for the minor, meaning the state, in other words, thinks it's a good idea that we protect that property for your children while you're a minor. Now, there's a couple of exemptions. The biggest exemption to this is the fact that if it's jointly held property with someone else, you can obviously get out of that restriction. But if it's property in just the single parent's name, it may be devised restricted under the state constitution. The other exemption out there that's applicable here is the spousal restriction. Now, many of you are out there and you've done refinances on your home and you've gone to sell property that was in just your name, but you were married and they told you, the underwriting company or the finance company told you, we need your spouse's signature. Many of you are beginning to understand why now. This is because the state of Florida says you may transfer your homestead property with spousal joinder, but the converse really shows you the rule. You may not transfer it without spousal joinder. So that means even though that spouse's name is nowhere on the deed, doesn't appear anywhere on the paperwork, you own the home before you ever met that person. You married, the spouse still has rights to that. So they're going to require their signature. So this is the public policy back and forth. We will give you creditor protection, but we will ask that you protect it for certain other people in your life that should be important to you, minor children, spouses, under state constitutional law. So if you have a question on Florida homestead, 877-943-9673, 877-943-9673. And of course, you can always email me your question. Lots of email questions throughout the week. I always answer each and every one of them. You can email me directly, patrick@attorneypatricksmith.com. Patrick@attorneypatricksmith.com, or give us a call now, 877-943-9673. All right, let's go to Kurt in Clearwater. Kurt, welcome to the Attorney Patrick Smith Show.
Thank you, sir. Thanks for having me on.
Yeah,
I
Kurt,
do have a great question for you.
fire away.
My question is, I know somebody that has a house that has a county tax lien for taxes. Can I buy that tax lien and foreclose on that house?
Well, you should always consult with your attorney regarding that. I've seen cases where people have done that and then really regretted it. So I think that it's a highly specific analysis. There's a couple of attorneys that we work with who have their own practices and guide clients through these sort of acquisitions. But a lot of times people just stare at what they can get that tax lien for and think, my gosh, I can steal this property. But you don't realize sometimes you're buying a problem. So you really need a qualified real estate attorney to walk you through that analysis in detail, Kurt, before you cross the Rubicon on that.
Okay, super. I will look into it further, sir.
All righty, Kurt. We appreciate you calling in. Enjoy the rest of your Saturday, okay?
Thank you. Enjoy your show. I listen to it every Saturday.
Thank you, Kurt. We appreciate your fidelity.
Okay,
All right, bye-bye.
Bye-bye.
All righty, 877-943-9673, 877-943-9673. And there's a great example. Kurt kicking off the show with an example of one of the exceptions to the constitutional creditor protection in Florida, where if you owe property taxes, they can file a lien against your property. So that will pierce that constitutional creditor protection here in Florida. So Kurt's call, a great example of one of the two openings, the other, of course, being the mechanics lien. 877-943-9673. Open studio lines. We'll get you and your call right on the air. 877-943-9673, or email me, patrick@attorneypatricksmith.com. All right, let's go down to Sarasota. Let's talk to Kathy. Kathy, welcome to the Attorney Patrick Smith Show.
Hi, thank you very much.
Hi, how's Kathy today?
She's doing good today. It's nice and sunny out.
Well, great. How can we help you?
I own a condo in my own name. I've owned it for 5 years. I have a domestic partner of 10 years. We're both older, so we don't plan on getting married. But I don't want to. I want to leave the property to him when I pass, if I should pass before him. But I don't know whether it would be best to put the property in his name and my name right now while we're both living, or whether I should do like a life enhanced estate deed.
Well, let's walk down this road and let's just try on each option and see which one Kathy feels best about, okay?
Okay.
All right, so if we devise the property to him, then he's going to get his interest when you pass away. And if we use a will for this, it's obviously going to be probated. If we set up some sort of simple trust, we can bypass the probate process and have it go to him. He's going to get a step up in tax basis. you're going to maintain independent ownership while you're alive and avoid any risk of gift taxes. So that's option one. Option two is putting his name on the deed. Now, first of all, is the mortgage free and clear on the property, or is there an existing encumbrance?
There's an existing encumbrance of about $50,000.
So if you're going to add another person's name to the deed, check your mortgage, have it reviewed by your attorney. There's probably what we call an acceleration or due on sale clause that may be triggered by that. And so unless you want them to call that note due immediately, you want to know ahead of time what the consequence is going to be under that note by adding a third party. Okay, so I would say check your note. And then number two on that particular option is if you just assign his name to it and do not have him exchange consideration with you, he pays you no money, in other words, that is what we call a taxable gift. Now, if you were legally married, I wouldn't be as worried about it because my understanding from conversations with accountants, and you should always check with an accountant on tax advice, but gift taxes between spouses are also usually deductible. So any tax generated under the gift tax for gifting money to a spouse would be deducted as well. So the net effect is you shouldn't have to pay anything. But remember here, like you said, you're not legally married to this partner. So I'm not sure that you would get that same exemption, and it probably could trigger some gift tax consequences. And then your last option, you mentioned a life estate deed or enhanced life estate deed. I don't hate that idea. I mean, I think those can avoid probate. I don't think they're a guarantee to avoid probate, and I'll demonstrate why. So if, say, God forbid, you and your domestic partner, I presume you guys spend a lot of time together, correct?
Yes.
Let's say you're in the same car accident. He dies before you, and then you die he died at the scene and you die on the way to the hospital. That's not going to avoid probate, because the enhanced life estate deed doesn't have a contingency plans for if your designated beneficiary under the deed passes away. The other thing I'm not crazy about with enhanced life estate deeds is it doesn't necessarily give you the same level of what we call incapacity planning that a living trust would. So if the property's in your trust, now not only do we have someone to steer your ship as to regard to your property and all your other assets, if you're incompetent, we've got a successor trustee to step up, stand sentinel, and guard against creditors or aggressive family members who may try to come in. But we've also got a great way to bypass gift taxes and to make sure the property is maintained in just your name and to provide a good contingency plan. The trust will say, if my domestic partner dies before me, then it goes to my siblings or my nieces and nephews or whatever you want. So I think that because of the contingency planning, the incapacity planning, probably some sort of simple trust may be the best answer for you, Kathy. But that's why we offer the complimentary consultation. Or if you already have an existing attorney, just call them and sit down and have that analysis with them.
Okay. Well, there's a lot to think about there. You put a lot of good ideas out on the table. I appreciate it.
Well, Kathy, in less than 5 minutes, that was about a semester of law school. So if your head is spinning, that's normal. Okay. Kathy,
it's spinning a little bit, but I have a decent grasp on it.
Well, if you need any other clarification, reach out to us at the office, and we'll give out the office line here in a moment, okay?
Thank you very much.
All right, Kathy, have a great day. All righty, this is the Attorney Patrick Smith Show, 877-943-9673. All right, Kathy, hanging up opens up a phone line, 877-943-9673. And now you are beginning to understand why. When I do my public speaking, and I had lots of presentations this last week, I had a great one yesterday at Villas de Golf in Largo. That's a condominium association, great group out there that had me. When I present there, I talk about how the number two misunderstood topic in Florida is the living revocable trust. But number one's Florida homestead. That last question sort of touched on both, but you kind of see why. Homestead is not this one thing. It's sort of this permutation of a thing, like an amoeba-like structure that sort of shifts into different issues as your life changes. The kids turn into adulthood. You remarry a new spouse. So these things are constantly shifting. That's why I think the biggest mistake I see in estate planning, people don't do it. The second biggest mistake, and it's a close second, is people do not update their documents. So if you haven't seen your attorney recently, call your attorney and get an appointment to review the documents with them. If it's been more than 3 years, that's my recommendation. And if you don't have an attorney, we'd be happy to meet with you. To reach us at the office, 877-754-6764, 877-754-6764. So that is the office line to be part of the show today, 877-943-9673. 9873. All right, next we are going to Oldsmar, and we're going to talk to Karen. Karen, welcome to the Attorney Patrick Smith Show.
Thank you very much.
How's Karen today?
So my question is, I'm doing quite well, thank you.
Great.
My question is, I bought my house in Florida when I was still married. We were going through our divorce. The house is in my name only. My husband lives out of state. If I were to die, does he have any claim on that house?
Probably.
And we are legally.
Yeah, attorney that represented you in.
Yes.
Yeah, I mean, you can always reach out to your former counsel and just clarify, but you may also just want to pull out your marital separation agreement they crafted for you and just read it. It probably addresses that specific issue in there. So you're going to live and die, no pun intended, by the words on the page of that MSA. But in most divorces, there's what we call a property allocation where they and there's also debts that get allocated as well. But you should just go back and take a look at that. And if you don't understand something in there or you don't see where it's addressed, just call your previous counsel and say, hey, I need a little peace of mind knowing that ex-husband has no claim to this property. And certainly by operation of just being an ex-spouse, he wouldn't have a claim to the property necessarily. And you said his name was never on the property, never affiliated with the property. The only right he would have had would have been during your marriage as the spouse under that constitutional analysis. And obviously with the marriage ending, he's no longer allowed to avail himself of those spousal rights.
Okay. And your office, do you only practice law for the homes for this kind of thing? Or can I come and just talk to you about all kinds of legal matters?
Well, you can come and talk to me about anything, but my primary day-to-day practice is wills, trust, and estates. I will say this, though, Karen. If you need an attorney, I've got lots of attorneys I've worked with over the last 16 years of being in practice, and I'll be happy to give you a referral to a couple of them, and they'll talk to you and kind of chat with you. So if I don't do it, I know someone who does.
Okay, and your office number was what? I missed that.
It's 877-754-6764.
I appreciate this more than you know. Thank you so much.
Karen, have a great day, okay?
And I love your show.
Oh, I appreciate your kind words. Callers like you are the reason why we do it, Karen. What station are you listening on?
Oh, gosh.
I didn't mean to put you on the spot, Karen.
No, it's, I can't see it because I'm driving.
Well, then, no, don't take your eyes off the road. It's not that important. Karen, enjoy the rest of your Saturday, okay?
Okay, dear. Thank you. God bless you.
God bless you. Bye-bye. All righty, 877-943-9673, 877-943-9673, or email us, patrick@attorneypatricksmith.com, patrick@attorneypatricksmith.com. By the way, you can check out the website, and you can listen to archived versions of the show as well. All that's available. You can request an appointment or book me to come out and be a speaker for one of your groups. All that's available at attorneypatricksmith.com. All right, next, let's go to a very patient Julie in St. Pete. Julie, welcome to the Attorney Patrick Smith Show.
Hi, how are you?
I'm great, Julie. How can we help you today?
I am curious. My parents are about to pay off their house, and we were wondering if we put the house in a trust, would it affect the homestead and save our home cap exemptions they have?
So this was the email question that kind of kicked off the show, and the short answer is it's possible to maintain the existing homestead exemption with a conveyance to a trust that acknowledges the fact that it's conveying homestead property. I think where you could sacrifice that homestead protection is where you transfer the homestead property to the trust, and one of two things is missing. Number one, the deed conveying the property doesn't recognize the fact that it's conveying homestead property. And number two, the trust does not acknowledge that it's receiving homestead property with some sort of present possessory interest language under Florida Statute 196. So I think as long as both those elements are there, I think that you'll be fine in maintaining the current exemption.
Okay. And this is something you definitely did with, that we could set up an appointment with you?
Oh, absolutely. I do this all the time. And Julie, be happy to give your parents a free consultation, look over everything, give them our thoughts, and help them with that conveyance of the homestead property.
Perfect. Then we'll definitely be in touch.
Julie, I'll look forward to it. Enjoy the rest of your Saturday, okay?
Thank you.
Yes, ma'am. Bye-bye. All righty, 877-943 9673 877 943 9673. That is your live and local number to be part of today's show. We've been discussing all things Florida homestead, although at the top of the show, I did kick off the question about the states that currently permit physician-assisted suicide or euthanasia, and was curious if you had any thoughts. So we encourage you to call in with all your legal questions, of course. But this morning in particular, if you have an opinion on whether or not Florida should allow physician-assisted suicide, or if you have a question regarding homestead, with our homestead deadline for the application coming up with March 1st. So again, any and all legal questions, welcome. 877-943-9673. All right, next we're going to Bradenton, and we're going to talk to Mary. Mary, welcome to the Attorney Patrick Smith Show.
Thank you. I really enjoy your show. I want to say that first off, and I've learned a lot.
Well, I appreciate you saying that, Mary. How can we help you?
Okay, I have a neighbor across the street who's approaching 65. His mother died 10 years ago, and she apparently had a will that the sister had physical control of. Apparently was never probated. The sister has since died. Whether the sister had heirs or not, I don't know. But there's one brother that he has that's pressuring him to sell the house. Now, he's been living in the house for the last 10 years, paying taxes, paying all the expenses and everything. And I would like to know, to be able to tell him where he stands legally and what his next step should be.
So, well, here's what I would advise. First of all,
Okay.
Mary, I think it's great that you're trying to help, but don't try to replace a qualified attorney. I think the spirit of what you're offering the neighbor, hey, let me help you understand, I think the best is great. But I think the best thing you can do is, hey, you need to go speak to an attorney. And the attorney.
Oh, absolutely.
Yeah.
Oh, I have no argument. He has no money. Which would be my next question is looking at this whole scenario. What with attorney assistance, obviously, what could be his expectation of an outcome, and what would the cost might be? We may very well be able to help him with legal costs.
Well, the only thing I can tell you on this analysis, Mary, is I don't know enough. I need to see the documents, but that's exactly why we do the free consultation. So if he wants
he has
to,
no documents.
Okay.
He's never seen the will.
So in that case, he needs to do something. He can file for an intestate action, an intestate probate, and that'll sort of force whoever has the will, if there is one, because there may not be one.
Okay.
Sometimes people pretend that there is and there's no will. So if you file intestate, you sort of force their hand to either respond with the will or your intestate administration goes through. But that's a consultation we would need to have with your neighbor, and there's no charge.
Sure.
So as far as a payment for that, tell him not to worry about it. It's not going to cost him anything. Just call that office line, set up the appointment. We'll go over all the facts with him and walk him through what he would need to do.
Sure.
And if there is some sort of fee, we'll negotiate that with him as well and put together a written fee agreement.
Sure. And one more question. What kind of legal standing would the brother have if you go through the intestate process? The fact that he has physical possession of the house, been paying on it for 10 years, but he's been living there for 10 years. So does the brother have, what, in terms of a judge, I know you can't judge what a judge would say, but what would the outlook be for him if he does this process?
I don't know. I wish I could give you an answer. But here's my thought. Here's what I think this is going to boil down to. If they're all beneficiaries who own this home by operation of the death of a loved one, and one person sort of moved in and started paying the bills and everything, that is probably going to be evidence in a subsequent partition action. Meaning, if they can't agree on how to divvy up those expenses and sell the property and the price for the sale, it's probably going to wind up in front of a judge. One party saying, hey, I should be reimbursed all these things. The other party saying, no, you shouldn't be reimbursed all these things. You should have been paying me rent the whole time. And it's going to come down to some sort of resolution. That's my best guess, but that is a very loose guess on that, Mary. And again, I just encourage him to schedule a consultation.
I totally understand. Yeah. No, that's been very helpful. And I will check with him, and maybe we can get him to come and see you.
Well, I will.
That would be the next step.
I will look forward to that. So, Mary, we appreciate you listening. On what station are you listening?
9:30 a.m.
9:30 a.m. I know if Mr. Weaver is listening right now, he is celebrating very loudly that you are listening on AM 930. All right, Mary, we appreciate you being part of the show. Thank you. We look forward to helping your neighbor.
Thank you.
Yes, ma'am.
Bye.
Bye-bye. All righty, 877-943-9673. If you've been trying to get in, Mary hanging up does open a phone line. So 877-943-9673. Next, we're going to go to James in St. Pete. James, welcome to the Attorney Patrick Smith Show.
How's it going? Good morning.
Great, James. How are you?
Good. I had a question about, so if you're in a partnership with someone for, 5 years plus, and you have a child together, what sort of, and you're not married legally, what sort of rights in Florida does a father have to the child?
Well, I think if you're the father on the birth certificate, I think you would have any sort of parental rights that Florida law would permit any parent. And I think unless those rights are terminated, those rights continue to exist.
And that's even dealing with like custody and things of that nature.
Yeah. I mean, at the end of the day, if it's a custody issue, just contact a qualified family law attorney and they can sort of walk you down the custody battle issue. But my understanding from other conversations with family law attorneys, the poll star that governs that is always the best interest of the child. And I think that's sort of what you would go into that conversation with, knowing that it's not about winning or about, making the other side feel disciplined for something they did. It's about protecting the child. And that's correct, at least based on conversations I've had. But again, I'm not a family law attorney. Don't pretend to be one, but I'd be happy to put you in touch with a couple who'd give you a free consultation and say, hey, here's what it looks like you're facing.
Okay. Awesome. I really appreciate it.
James, have a great day. All righty. 877-943-9673. Devin in Lakeland. Devin, you're our next call on the Attorney Patrick Smith Show. How are you today, Devin?
I'm well. Thanks for asking. My comment really was about the physician-assisted suicide. It just gets to be a slippery slope. I actually had a cousin who passed away a year and a half ago. He had AIDS. And he just got tired of living. So what he did was he stopped taking his antivirals and he literally just slowly faded away over like 3 months. And so I know had he had the option, he definitely would have taken that. But where do you draw the line? Because it does remind me of Dr. Kevorkian. I don't know if you remember that. Maybe I'm aging myself by saying that. But
no, I do.
Yeah, back in the day, Dr. Kevorkian, which he was kind of a menace too, but how do we choose who qualifies and who it's a good choice for? And, where do you draw the line? Because I think about the legal ramifications of family members suing because maybe, they felt like they should have been consulted or they felt like maybe the person was just depressed. What's your take on that?
Well, let me turn it around on you just because I'm a lawyer and we answer questions with questions around here. So you mentioned that it's a slippery slope, right? And so you have someone, let's say someone is 104 and they are stage 4 terminal cancer in constant agony. No sort of relief is available to any sort of medication. Would you be open to that person availing themselves of physician-assisted suicide?
I'll be honest with you because I'm all for palliative care, blah, blah, blah. After 100, baby, I feel like you should be able to do whatever you want to do because you've lived your life and somebody else's. So
we've established that there is an age, and over 100 is Devin's age. She said over 100, you're good. So let's go to and I noticed the way you said palliative care. Are you a physician?
I am not. My husband is.
I knew there was a physician or some sort of medical background in the mix. No one else calls it palliative care. So let's go to the other bookend, okay? Let's say that a parent has a minor child who is terminally ill and in constant pain. Should they be allowed to decide that decision for their minor child?
Don't do that to me. I don't know because I'm going to tell you why. As a parent, and especially in Florida, you can. Let's put it like this: these kids now can go to the doctor and get birth control. They can get abortions without parental consent. So I don't necessarily agree with that, but I feel like that is not a burden that should be placed on the parent, to decide when the life ends because a child is a child. A child does not have the mental capacity to fully understand the ramifications of their actions. They just know they want to not be in pain anymore. And as a parent, you're going to sympathize with your child, and you feel what your child feels, and you don't want to see them hurting. So I think that the moral compass can be skewed when it comes to your own child. However, I also feel like, medical cruelty is a real thing. People should not suffer when they don't have to. If that's an option, I feel like there should be extensive family counseling, mandatory, 6 months at the least, so that they have a full scope of what it is they're doing. Because as crazy as it sounds, people need to understand the permanency. You would think that's an immediate thought process, but common sense is no longer common, especially here in good old Sunshine State. So I feel like 6 months of mandatory familial counseling, as well as waivers need to be signed. You cannot turn around and sue physicians. You cannot, because I see that happening. I do.
Why?
I do.
So people sue physicians? Is that what you said? I'm just kidding.
Oh,
I'm just kidding. Yeah. No, Devin, Devin, you did a great job answering that question, by the way. I applaud you. But I asked the question to point out the issue. It's a difficult topic. And that kind of demonstrates your slippery slope argument. Where do we draw this line of demarcation? And it gets very, very difficult because it has to be intensely fact specific to that situation. But, that's where, tough decisions can result in sometimes bad laws, and that legislatures aren't perfect, but these sort of things have to make their way through committee, and they're not easy topics to address. But I think you said your husband's a physician. Has he ever talked to you about something called a physician's order on life sustaining treatment, or a POLST?
Yes, but when he does, it's kind of like he's speaking Greek, so I just smile and listen. So he has a listening ear, but I don't really fully understand the scope always of what it is he's telling me,
Yeah, so, you ask your husband about that, but that's where basically, as I understand it, physicians, and if there's a physician out there who wants to call in and speak to it, they're welcome to. This is basically where a physician gets to the point to say a patient's so far gone that I'm ordering nothing to be done because all we would be doing is prolonging their suffering. So if the physician can decide it for the patient, I think some would say, why can't the patient decide it for themselves? And I think that would be an argument, especially if you're in that condition. So I think you're right. I think it's a functionality of all these issues. There's sort of a calculus going on here. It's the nature of the illness. It's the age of the person, the diagnosis. I think you got to take all that in consideration, but all that makes it extremely difficult to draft legislation that would address that adequately.
It does, because I've spoken to people who, literally are, oh, I'm ready to end it all. I have nothing else to live for. Then they get on medication, and a year later they're like, oh God, I'm glad I got help. So what if that person who's so suicidal in that moment, and it is real, those feelings are real in that moment, but then a year later they're like, God, I'm glad I got help. I'm glad I got Baker active because I'm still here. I have something to live for. What if in that moment they're just like, okay, let them commit suicide, and they have so much life left in them, it's just, I don't know. Maybe I'm an eternal optimist. Maybe that's what it is.
Well, and you're right. There's no refund policy with sort of physicians-assisted suicide. So that's a fair point. And actually, one of the topics that I had to discuss today, I always have way more than we can actually get to in the broadcast time. But one of the topics I was going to talk about was, do you know who Twitch is?
Yes, I do. Oh my God, with Ellen. Oh my God, yes.
Yeah. So a lot of people, who love the Ellen Show, watch Twitch, is her DJ, who's an amazing performer in his own right, and he passed away due to suicide. And by the way, if you're out there and you're having those sorts of thoughts, there is help and there are resources available to help you in that time. So if you dial, I believe it's 988. 988, or you can text 988. There's a resource out there to help you through that, so you can face those dark thoughts and realize how temporary they are through the help of someone to assist you through it. But his wife is actually going through the consequences, and I think that's where a lot of people have to consider that in the legislation as well, the consequences it's going to have for the family, because now she's out there. He had no plan in place, so I think that may be one of the requirements, that if you're going to do this, you've got to show that you've got the proper planning in place for the family, because now his wife, God bless her, is out there petitioning the court through intestacy because unfortunately Twitch had no planning in place. And that is, I think, a lesson to be learned. I mean, obviously, you obviously want the person to not commit suicide. But at the end of the day, if they've done that with no planning, it makes it worse, and it piles on top. It's bad getting worse, and it just keeps this cascade of trauma crashing on the family. So I say that, I had the story as a piece to do about intestacy, but with this sort of physician's assisted suicide piece, it sort of dovetails there. So I think that that's the lesson there is we'd probably want to see something in the legislation, Devin, that said they have to show they have proper planning documents for their family in place.
I agree, but I 100% agree. I also would like to see something, especially when it comes to people of color, because I am African American. When it comes to people of color, specifically male people of color, there's a disproportionate percentage of Black men who deal with mental health. You made me think about that when you mentioned Twitch, that are afraid to actually seek help because they feel like their symptoms are either kind of brushed away, or they just don't feel seen, or there's this whole toxic male energy that I'm no wuss, I don't want to go seek help. So I think if there was a bigger focus on mental health, then we would have less of a need, because I'm not talking about people with, like you said, terminal illness or things of that nature, but I'm talking about a lot of it is mental health related. So
and you mentioned people of color. So Devin, if you have a moment, Yumiko actually has prepared a piece in honor of Black History Month. So Yumiko, I'll just turn the mic over to you, and Devin and I will sit back and listen to your piece on Black history. Please, Yumiko.
Okay. So this is about Crispus Attucks, who was the first African American hero for the Boston Massacre. So he was born in 1923 and he died March 5th, 1770. So his father was Prince Younger, and he was a slave who was brought to America, while his mother is Nancy Attucks, a Natticut Indian, and William Brown is a resident of Framingham, Massachusetts, advertised for the recovery of a runaway slave named Crispus, who usually thought to be Crispus in question. That advertisement proclaimed that Crispus had ran away and described him as a 27-year-old, 6'2", in the 20-year interval between his escape from slavery and his death at the hands of British soldiers. Attucks probably spent a good deal of time abroad whaling ships, and all that is definitely known about him is the Boston Massacre on March 5th, 1770. Towards that day, a crowd of colonists gathered and began taunting the small group of British soldiers. Tensions mounted rapidly, and when one of the soldiers was struck, the others fired their muskets, killing 3 of the Americans instantly and mortally wounding 2 others. Attucks was the first to fall, thus becoming one of the first men to lose his life in the cause of American independence. His body was carried to Faneuil Hall, where it lay in the state until March 8th, when all 5 victims were buried in a common grave. Attucks was the only victim of the Boston Massacre who was named widely remembered. In 1888, the Crispus Attucks Monument was unveiled in the Boston Common.
Wow. Yumiko, when Yumiko sent me that, Devin, I was really excited about it. So Crispus Attucks, American Revolutionary War hero. Mm-hmm. So Yumiko, thank you so much for that. Devin, thank you for being an amazing caller. Really appreciate it. How is everything in Imperial Polk County this morning?
I haven't heard that in 10 years. It is great. The weather's nice. Beautiful day. We're going to go hit the farmer's market. But yes, it's a great day to be in Florida.
Well, have fun with the good doctor, and we appreciate you calling in.
All right. Have a good one.
You Bye-bye. Too, Devin. Bye-bye. All righty. The number, 877-943-9673 to reach us at the office during the week, by the way. That toll-free number for Clearwater, Sun City Center, Sarasota, 877-943-9673, 877-943-9673. All right, Chris in North Tampa. Chris in North Tampa, welcome to the Attorney Patrick Smith Show. I have about 30 seconds, Chris. Can you make it quick?
Okay. Is this football talk with Patrick Smith?
This is Patrick Smith. That's right.
I enjoyed last week's show much better than this show. It was just a little depressing.
Well, I appreciate your honesty, Chris. Go ahead. You have about 20 seconds left.
I just wanted to say I called you this past weekend, and I figured you'd get back to me sometime at the end of the week or next weekend. And I just want your audience to know, man, that you got back to me before I could put the phone down. It was amazing. So I was really impressed with that. Is there any way I could go on hold and just talk to you for a couple minutes? after
Yeah,
the
so
show?
I'll have you, Miko, put you back on hold if you don't mind, you, Miko or Brian. And Chris, I'll talk to you off the air and I'll wrap up the show. Okay.
Thanks, Patrick.
Thank you for your kind words, Chris. Talk to you soon. All righty. So if you want to be part of the show next week, 877-943-9673, 877-943-9673, or reach us during the week at the law office, 877-754-6764. Come see us Wednesday night, 6:30, Smiley's, Indian Rocks Baptist Church. And if you want to book us to be a speaker, email me, patrick@attorneypatricksmith.com. Congratulations to my Florida Gators who won their season opener last night against Charleston Southern, and actually Mercy ruled them, brand new rule. So everyone stay tuned for the next program, and we'll see you next week.
The proceeding was sponsored by the law offices of Patrick L. Smith.